Good afternoon, everybody, and welcome. My name is Jim Bennett, and I am the Acting Board President of the Nebraska Juvenile Justice Association. And on behalf of the association, I want to thank you for your participation in this very first installment of the NJJA webinar series. With the help and support of the Sherwood Foundation and the University of Nebraska Omaha's Juvenile Justice Institute, NJJA has begun expansion of its 3 core. And for more information on upcoming educational opportunities, please go to njja.org and sign up for our mailing list. A couple housekeeping things before we get started today. Please make sure that your name appears on the right-hand side of your screen as we're noting attendance for the live webinar session. If you only have your first name, please take the time to type in your full name so that you will be acknowledged for having attended the live session. Also, please utilize the chat function throughout the webinar on the right-hand side of your screen for all questions. We will, in the interest of time, we will keep track of those questions as you write them down, and we will answer those or get to as many of those at the very end of the webinar to get that to you. This webinar will be recorded as a resource and will be able to be accessed through njja.org in the very near future. We will send out information on how to access that. More information about what that will be sent through our mailing list. Also, another reminder to please hit *6 if you have not to mute your phones. So let's begin. It is with great appreciation and excitement that I introduce to you today Lindy Bryson, Field Operations Administrator from the Department of Health and Human Services, Children and Family Services. Carrie Rumbaugh is also here today as she is the Assistant Deputy Administrator for the Administrative Office of Probation, Juvenile Services Division.
All right, good afternoon, everyone. My name is Rumbaugh. We're going to start just by introducing ourselves to all of you. Please let us know for some reason if you can't hear us. Please do type in any questions that you may have, like Jim had said earlier, in the chat box. But we're just going to quickly start by introducing ourselves, and then we will start rolling with the training. Like I said, my name is Carrie Rumbaugh. I am the Assistant Deputy Administrator over Juvenile Services with Probation Administration. And I started probation in 2000 as a juvenile probation officer, moved to the administrative office in 2006, oversaw interstate compact, compliance, and an AmeriCorps program with the Administrative Office of Probation, and moved not too long ago, October of 2014, to the Juvenile Division. So I'm excited to be here with Lindy to be able to present this training today. This is the same training that we presented at NJJA this year, and so we're excited that we'll get to bring it to more of you than those who were just in attendance at NJJA. So Lindy, if you want to go ahead.
Hi, I'm Lindy Bryson. As Jim mentioned, I'm the Field Operations Administrator. My background started back more than 30 years ago. I worked with protection, or is known as Protection and Safety then, which is now Children and Family Services Specialist. Started as a worker, moved up to being a supervisor and administrator. Most of my direct experience was out in the rural area, although I did work a bit of time in Omaha, and then Lincoln, and now I have responsibility for all the service area administrators and staff out in the field.
Okay, so what you'll see here are the objectives that Lindy and I will be going through in regards to the training today. So I'm just going to quickly go through these, and then we will go through them in more detail as we go through the training. We're going to first identify some reform changes. We're not going to get into the little details. We know most of you know about 561 and 464. We just wanted to kind of start the training with that because it's a big piece of why we talk about, or how we talk about, juvenile reform in Nebraska. So we are going to start there. Then we're going to go in and start defining roles. As Lindy and I have been working together, one of the things we both found out is that we were not clear on each other's roles, and it was very helpful to talk to each other to become more clear, as well as the fact that we use similar language and mean very different things. So we're going to talk about that. We're also going to then go into the understanding of the different intake processes with child welfare. And so that's specifically one of those definition areas where we use a similar word that means something very different. We will outline how we utilize out-of-home placement for youth, and then finally we will demonstrate collaboration with youth in both the child welfare juvenile justice system Some of you may refer to them as crossover youth. And so we're not going to get into the details of the crossover youth piece, but we want to talk about dual adjudicated youth and how we can work with them and benefit them and their families. So I'm going to start quickly with talking about LB 561 and 464. So nationally, I'm hopeful that many of you know, nationally there really has been a push for juvenile justice reform. And then the key impact of that in Nebraska was the passage of LB 561 and 464. 464 was really the cleanup bill to 561 that pushed juvenile justice reform. But one of the most important pieces of reforming a juvenile justice system is to make sure youth are served in the agency or in the system that best meets their needs. And so that's what we're going to talk about mainly today, how child welfare and juvenile justice are very different, and we do meet needs in a different way. And there may be times where both of us need to be in place to really help a youth and family. So that's what Lindy and I are talking about. So here are some key changes and key pieces of why did we implement juvenile justice reform and why is it so supported on a national level to implement juvenile justice reform. One of the pieces to this was ensuring youth were not made a state ward.
The caller
April Manga.
has joined the conference.
Just because they needed to receive services. So prior to implementation of 561, for youth or family to receive services they couldn't receive in Nebraska, they were made a state ward. So one of the goals was how do we make sure that those parental responsibility stay intact and a youth can receive services at the same time if they don't need to become a state ward. The second then is that child welfare really has an expertise focus, and that's abuse and neglect. The reform bill allowed child welfare from before where they had a lot of delinquent youth under their supervision to really pull into that important piece of our focus is abuse, neglect, and our expertise area is. Lindy, do you want to say anything else about that bullet point?
No, I think you answered that well, Carrie.
Okay. The next then is that delinquent and status youth are now solely supervised by probation. And so again, we're looking at that piece where child welfare's expertise is abuse, neglect, probation's expertise is delinquent youth and working with youth that are status offense youth. So that's another piece that the bill clarified. It also then gave the authority of the Office of Juvenile Services to focus their complete goals on the YRTCs, or the Youth Rehabilitation and Treatment Centers in Kearney and Nebraska. So they were previously working with all of these delinquent youth that were then becoming state wards. Well, now that probation is supervising those, they can take their focus and really examine on the two YRTCs and make sure that those are running as well as they should be in Nebraska, and really looking at national research and how that supports that highest level of placement that we have for youth. So that was they were able to focus on that. The next is then the court is playing a key role in the reentry process. So that is a big push nationally that the court is involved in all of the steps within the system. And so
The caller
Brianna Johnson
has joined the conference.
the court did not play the key role in reentry, and so now they do, with a collaboration between probation and the Office of Juvenile Services, which is wonderful that that collaboration happens. And then finally, we just wanted to empower families, and so that self-sufficient family is essential, and that was another push within the legislation. They remain the legal guardian, and they're empowered in that way to make those difficult decisions for their children. So those are really the big changes that occurred with that legislative change and some of the reasons why that happened. So now we're going to get into some differences and talk about our role when it comes to child welfare and juvenile justice. So in these next few slides, you'll see some clarity among those roles. I did forget that I wanted to note as well, you'll see up in the corner of your presentation, I'm kind of putting the green arrow over by it right now. We do have the PowerPoint available for you. If you simply click on it, it will let you download it to your computer. So you can also have a copy of the PowerPoint to take with you after the training today. So I'm sorry I didn't note that sooner. Do you want to start?
Sure, I can start first. The next slide that you see is about what our focuses are. And in child welfare, our focus is child safety, permanency, and well-being. That is, on a national level, the focus for child welfare. Then the second bullet indicates about our completing assessments. We do use an evidence-based tool to complete assessments related to safety and risk of child abuse and neglect. We also coordinate community services. And our plan is to try to safely return children home. There are times, sometimes children cannot be returned home, and so then we have some other options, which we'll talk about a little later in the presentation about what those other options are for children.
And then on the juvenile justice piece, our main focus is delinquency, community safety, and behavior change. And so as you'll see, there's a very big difference between the two of our roles. And sometimes because child welfare was doing some of the delinquent work previously, it can get confusing, and sometimes they think probation will work on permanency and they think child welfare will work on delinquency. So the most important piece, and I really think these first two bullets in both of our areas are almost the most important piece to really clarify the difference of our roles. So probation really is looking at a youth who's been involved in some delinquent or status act. There may be a community safety risk in regards to a delinquent act, and a status act, we're looking at some sort of behavior change. And so that's really our ultimate goal when we're looking at success in probation. That's our focus. You'll also see probation's main focus as well is supervising conditions, and these are court-ordered conditions. We really look at ourselves as that support or arm of the court, and also targeting case management. So we utilize our assessment tools, which we'll talk a little bit later. We utilize those to ensure that we are assessing to know how should we case manage and what should we target on to address what you see in the first bullet. Ultimately, you'll see both of us really focused on keeping youth in the home, and child welfare more on a safety, and probation more on a delinquency focus. Can the youth maintain in the family home, and is their delinquency causing them to possibly be removed from the home? We both want to utilize interventions that are least restrictive and really within their communities. And that, again, we talked about the national push of juvenile justice reform. That's also a very essential national push that youth really do strive and have more success within their family home and their communities. And so that is a goal of ours. And with child welfare, it's more a goal if it's safe, and probation is a goal if a youth can maintain their delinquent behaviors within the home. All right, so we talked about assessment. So Lindy, you'll go ahead.
So the next are about our assessments and how those are different as well. In child welfare, we have a risk assessment that we use and a needs assessment. But the risk assessment really is about what's the likelihood of future harm to the child. And also then the needs assessment is how are we going to meet the needs of the child, how are we going to manage and care for their well-being, which could be medical care, could be educational care, behavioral health needs, and then last is about securing permanency. Where are they going to be? Who's going to be caring for them in their future? Are they going to be returning back to their parents? Is there someone else that they're going to be permanently a part of somebody else's family, like through adoption or guardianship? But we are not interested in being a forever guardian of a child and really want to get them to someone in more of a family-like setting as quickly as we can.
Great. And then, as you'll see on this slide, you can see quite a difference between what the child welfare and juvenile justice goals are. So under juvenile justice, you'll see that our goal in regards to assessing risk and need is to assess for future delinquent or status offense acts or behaviors. So that is ultimately our goal. So we utilize the youth level of service instruments, and that's really how we look at what is our risk and what is our need. And we focus that on the risk, need, responsivity principle, that we need to be responsive to the needs that may that may exist with a youth so that we can ultimately impact risk. We want to see their risk for delinquent acts reduced, again, really looking at reduction of risk, but also that reduction of recidivism, that importance of community safety that you saw on the previous slide.
The caller has joined the conference.
That's a good pause time. Okay, now we're going to talk about intake. So this is one of our first terms that we use the exact same term with a completely different meaning. So I'll have Lindy start with the child welfare piece.
Sure. So as mentioned earlier, that our focus is on the protection of children from child abuse and neglect. But the first entry into our system we'll often refer to as an intake, that the CPS hotline receives a call from either someone in the community or it may be a report from law enforcement, and we refer to that as our intake. From there, the CPS hotline will use a tool that they screen for the allegations of maltreatment and the potential risk of harm to children. Sometimes reporters will call us with things that they're concerned about, but it may not meet the definition of maltreatment or rise to the level, a significant enough level of potential risk of harm to children, and so we call those are screened out. So sometimes you may hear, well, someone called the hotline, but CPS is not going to be responding. And that may be accurate because it doesn't meet the definition of child abuse and neglect. This is really then the first entry point for us. If there's, unless there's a court order, and there are times sometimes we will receive a court order that a court has made a child a state ward, and now we are responsible because the court has given us that authority. But without an order, this is the place where it starts for us. And this is not, the hotline is not the staff in the field. The hotline are located at Project Harmony. It's a 24/7 operation. There's over 40-some people that are responsible for accepting calls. And so they really, through the standardized tool, make a determination, is CPS going to become involved or not.
Great. And so probation's initial involvement looks a little bit different, but you'll actually hear me say some similar things that Lindy said because we do have a similar focus, but it just looks different. So with juvenile justice, our intake really involves a new law violation or a runaway. And so this is when law enforcement will bring a youth to a probation officer to determine if a detention should occur. And ultimately, the police officer can determine to cite and release at any time. But if they are concerned that the law violation or runaway behavior is significant enough to want them assessed for detention, then that's when a probation officer would come involved in that situation. We do have a standardized screening tool we utilize called the RAI, if you've heard of it before. But one of the most important pieces of that is it is a moment-in-time screening. So we aren't screening the lifetime of the youth. What we are screening for is that immediate safety concern of why that law enforcement brought either a law-violating youth or a runaway to a probation officer to screen for possible use of detention. In that screening, we also have the ability to utilize other options. So like Lindy said, if a youth doesn't screen appropriate for the hotline to investigate or really initiate, we also have the same screening where probation can release a youth who law enforcement has brought in to determine detention. So we can choose that we will not detain a youth at that point utilizing our tool. What we're ultimately looking for is that community safety risk. So will we see the youth being able to go to court? Will they show up in court? And are they a huge risk to the community, themselves and the community? So those are those moment-in-time things that we are looking at when we utilize an intake. So sometimes there's some confusion around detention and the utilization of detention when it comes to probation, or why maybe a probation officer wouldn't utilize detention, but a youth has to score very highly on this instrument because detention is ultimately taking away someone's rights completely and placing them into a detained status. So it's very important that a probation officer takes the time to screen and only detains the youth when appropriate. And again, just like Lindy and I said at the very beginning, we're looking for those less intrusive opportunities to help a youth not have to be detained if it's not necessary. So those are those initial involvement intake pieces. Okay, go ahead, Lindy.
Okay, so then to talk about placements a bit, in child welfare, one of the things that we wanted to clear up or clarify is that Child Protective Services, CPS, cannot place children in detention. These children have been determined to be abused and neglected, even if they're also with probation. But our focus is, or our authority is, we can't place children in detention. We do not have the legal authority to do so. Placement of children, then, can only be done if the court has ordered us to have that authority. There are instances where there's an immediate need for removal. CPS, child welfare, cannot remove children, but we can, law enforcement can, and then law enforcement can remove a child if they believe the child to be in imminent danger, and within the next, and they're taken into protective custody by law enforcement and delivered to to Department of Health and Human Services for up to 48 hours. Within that 48 hours, we have to receive a court order for us to continue to have a child out of home. All of our requests to have a child placed out of home have to be approved or ordered by the court. There are some emergency situations if a child is a state ward that we can make a decision to remove a child from that home or from that placement, but we have to notify the court within 48 hours, and they still have, the legal parties have the right to have hearing to know more information about that placement change. But it's just very important. Some states, the child welfare workers or CPS workers, or as we call them, children and family services specialists, have that authority to remove children and place children, but in Nebraska, we do not.
So this is one of the ones when Lindy and I got together and talked, really stuck out. It was very helpful, and so that's why we wanted to bring this to all of you and as many people as we can in regards to this clarity piece. So when you look at juvenile justice, you'll see, again, like I said previously, the use of detention is limited to continued law violations or that public safety piece and fleeing the jurisdiction of the court in that moment in time when we're doing an intake on a new law violation. So when we look at placement, probation can utilize detention or an alternative in that situation if deemed appropriate, and our screening tool supports it, and a probation officer has done everything they need to do to assess the situation. In regards to placement or utilizing some sort of out-of-home placement, like Lindy said, you'll see very similar language between the two of ours, that a youth must be placed in out-of-home, but it has to have an accompanying court order. So there is some confusion sometimes that probation can place a youth in a placement without the court ordering it, and probation cannot do that. So it's very important that even in some situations where Lindy said in some abuse situations that are very significant, that they actually can place with a 48-hour court order, probation doesn't have the authority to do that unless we are choosing that we must detain. We do have a 48-hour clause where an arrest could occur, but again, it has to be extremely significant when we would utilize a situation like that. But again, we always have to include the court when it comes to a youth who is in any kind of placement. Everything has to be court ordered. Okay, so we thought it was important to also talk about when is a youth successful within both of our systems. So if we're talking about a Health and Human Services worker who closed a case or a probation officer who recommended closing a case, why do they do that, and why is it maybe sometimes confusing for both of us? So I'll let Lindy start with child welfare on this one.
So as the first bullet in the PowerPoint, safety assessment is determined the child to be safe. So anytime we're looking to close a case, we have to ensure that when we're no longer involved, that child can be safely in that home. Again, I think I mentioned earlier, but we have an evidence-based safety assessment model. It's called structured decision-making, and that's the tool that we use to determine that the child can now be safely in their home, and we can close the case. Another factor is about the risk. We also want, not only are they safe, but that we have made some impact on the reduction of a future risk happening to that child through a risk assessment. It could be at the time that we became involved with the family, that their risk, their potential for future harm was high or very high. And now through various services or interventions, we've been able to help that family move into a lower level of risk, either low or moderate. And so we're feeling successful with that when we've been able to help the family make that move into a lower risk level. And then also there has to be permanency for the child, and that permanency can either occur through unification, which is most of our children do return back to their family of origin or one of their parents. Sometimes they may have been removed from a mother and now they're going to have permanency with their father, but they're with one of their parents. It can happen sometimes. Children, despite our efforts and despite the efforts from the family, we just can't get the children reunited safely back with their parent, and so their permanency then becomes adoption. And that is where then that person who adopts has all legal responsibility for that child, just as if that child was born to them. So sometimes there's even confusion. Well, they're adopted and you're providing a subsidy, so can you assist with something? There's subsidy programs available to help that family, because if they've been receiving a foster care payment, it may be a bit much to take on another child without some type of financial support. But all the responsibility, decision-making belongs to the parent, just as if that child was born to them. Or the child could achieve permanency through a guardianship. In that situation, a court would remain some level of jurisdiction, and so the family may have to report to a court. But again, the department, our authority and responsibility of that child ends at the time the court releases us after they've granted a guardianship. Some of our children do have a permanency objective of independent living. We'll see that with some of our older youth. They might still have some connection and involvement with their parents or other family members, but it's really not the plan that they're going to move back into their parents' home, but rather they're going to transition into their own living arrangement. Maybe some of the kids do maybe go to live in dorms and go to college, but they're just not going to be back in their parents' home. There's another goal that we don't see very often, but it's called self-sufficiency with supports. And those are typically maybe youth that have some developmental disabilities or some medical needs. They're not going to be living with their family. They can't live independently or fully independently, and they're going to be maybe living in an enhanced or in a DD home, or they're going to be living in a DD group home and something like that. Some of those kids do end up with a guardianship, but they may not achieve guardianship till after they're 19.
Great. Okay, so then you also see where the juvenile justice piece fits with the successful termination. And so like I said before, when every single service, especially out of home, is something that's supported by the court, most of those you'll see within a probation order, or probation conditions. So when a youth completes all of their probation conditions, that is a way to successfully look at a youth doing well and being successful on probation. So we want to look at completion of all of those terms and conditions. And some of those terms and conditions are kind of a checkbox that they just need to do and be done with, and some of them are long-term, like success within a school environment. So we see different kind of probation conditions, some more quantitative and some more qualitative, that our probation staff supervise. The other important piece of that successful termination then is behavior change. We really look at it as a probation officer as a behavior change agent or a change agent. So we work very hard to target those risks that a youth has to help them then target what they need to do with their probation conditions and get off of.
The caller,
Janet,
has joined the conference.
But, for example, with probation, when a youth, for example, a youth may have substance abuse concerns, and until we address those substance use concerns, we won't be able to really move to some of those other pieces that may be probation conditions. So we really look at that behavior change and also how do those impact probation conditions. And then finally, we want to see that reduction in recidivism. So we look at risk reduction as well as reduction in recidivism. Our goal is to have youth successfully leave probation, not come back as either juveniles or adults. So it's very important to us that recidivism piece is there too. Okay, so we did dig in pretty good to intake, but we did want to point out a couple additional pieces and just get a little more detailed with that. But you'll see here we kind of talk about apples and oranges. So again, using the same word, but it means very different. And so we wanted to really kind of get into the weeds a little bit with the intake piece because Lindy and I hear a lot of questions about that and some confusion about that. So we thought, let's dig in this a little deeper so that we can give you some clarity around this as well. So we're going to start with the role of HHS and intake, and so Lindy will kind of get into this more and share with you some expanded information from what she spoke about previously.
Okay. So again, our first contact is either going to be through the hotline or it could be the law enforcement is contacted and requires the assistance from us to assist maybe in a removal or some intervention for the family, but again, it has to meet the definition of child abuse and neglect. The hotline does use a standardized tool, and again, it's structured decision-making. So we start with our structured decision-making tool at the very beginning of the intake, which is the same tool that we use in assessing and all the way to the closure of a case. But we do start it with intake to determine if it meets criteria for an investigation. And some things, too, about the intake process, if you've ever called the hotline, you may be familiar with, we cover more than just what the allegation is. We have questions about, well, tell me about the child and the family. Tell me if there's substance abuse, domestic violence. We want to know as much as we can or as much as the reporter can tell us about this family before we are going out and making contact with the family. And sometimes reporters may call in about one condition, such as maybe a dirty house, but they didn't even think about, well, maybe there's drug usage going on in the home, and we also need to know about that before we enter the home. So it's a pretty comprehensive assessment that we're even trying to do at the very beginning to find out, does this family, should we be accepting this for further investigation? Once the hotline has received or made a decision, a determination that we will accept this for investigation, we have 3 different priority responses. We must make contact with any of the identified victims in the family or the children in the family. Priority 1s are within 24 hours. About a year ago, we also looked at this because these are very serious ones. These are maybe head injuries or life-threatening situations to children. And our response time is typically we're out there within 4 hours. So that's from the time the worker got the call, looking maybe at some initial information. Is there any historical information they're coordinating? Sometimes they're coordinating with law enforcement to go with them and actually in the car, and they're making a very prompt response in those situations. There's also times law enforcement may already be at the house. It's been that serious. They were contacted first, but we're still out there then within 4 hours to make contact. Priority 2, we have up to 5 calendar days. Now, I don't have in front of me what our average response time is at, but I know many times we're out there much before the 5th day because, and these are maybe they're a little bit more serious. Maybe there's bruises to a child, but it's not a life-threatening situation, but it's serious enough that we know we need to be getting out there pretty quickly. Then priority 3s are still, they're accepted for investigations, but they may not be quite as a dangerous of situations. They may be things more like where the home conditions aren't up to the standard that they should be. Or there's sometimes some situations, too, we might prioritize a situation to know maybe it was the child's with one parent, I'll say with a mother today, but they're not going to the concern is about the care by the father, but they're not going to go to the father's home until next week. And so we have some time here before we need to make contact because we always want to have enough, we have to have enough time so we can get out those priority ones right away, and then maybe the ones that aren't quite as concerning, they might wait till the next day or to the following week to follow up on and make initial contact. And as I said, if it's accepted for an SDM assessment, we could also have what we call court or non-court interventions to be offered. So this is something that I think that's also very different between us. We have what we call non-court cases. So we go out and we assess, and we could determine that the child is unsafe by the parent, or sometimes they're in a caretaker situation. It could be a grandparent, it could be a legal guardian, or someone else that has some authority to provide care for the child. So if they're unsafe, that we are going to open a case. We don't even have to go. We'll still do an assessment, but if they're unsafe, that is enough cause for us to become involved. If the risk is high or very high, so we are going to become involved, or at least offer to the family we could become involved. So they could be safe. It's not imminent, but our assessment tool tells us that there's a high or very likelihood that if we don't provide some level of intervention, that we're probably going to get another report on this child, and even worse, if they're very high, there's even a higher chance that we're going to see a removal of this child in the future. Another thing with our assessment, though, when we're in a non-court case, we cannot place a child out of the home. There are some families that, in our non-court cases, where we call informal living arrangements, that maybe the mother or the father, they know maybe their situation isn't real good, or maybe they need to take care of some business, like some of them maybe need to go to treatment right away or do some things where they can't be taking care of their child. But they are voluntarily letting their child go with a safe caretaker, and we call those informal living arrangements. We don't fund those placements. We don't have control over those placements. So the parent agreed that maybe I'm going to go to treatment for a few days, or I need to go to some intensive treatment, but I'll be back out next week, and my mother's going to take care of my children while I go. That's totally up to the mother. If now the mother decides she's not going to stay with that living arrangements, we'll have to reevaluate. Do we need to ask for a filing to ask if the children can be made state wards, because she's not following what we call the safety plan, or she's not following what she's agreed upon. In the court cases, as I mentioned earlier too, though, that's when the court has made the child a state ward, then we have a different kind of legal authority and responsibility over the child. So in a non-court case, it's really up to the parent to decide if they're going to agree to work with us or not work with us. If we're worried about the child, if the risk is very high, or the child's unsafe and they refuse to work, those are the times where we may be asking the county attorney if they would be filing a petition to allow us to have legal custody of that child.
Okay, so then the next piece is then that role of probation at intake. So like I talked about previously, we're only looking here at new law violations or runaway. And again, this is when law enforcement requests that probation assessed for detention. So like I said before, law enforcement can cite and release. They can pick up a runaway youth and take them home. So they absolutely have the authority per statute to do that. But when they are concerned, then they would bring the youth to probation for this intake screening. And so I did say some of these before, but I just wanted to really touch on them quickly again because I think it's so important. But so criteria for detention, you'll see 3 criteria here. If the youth is a risk to the community, a risk to flee the jurisdiction, and a risk to fail to appear in court. So those are really the moment in time when we do an intake, what we're looking at to see what we need to do. And then even if we do place a youth in detention, our goal right away is to have a court hearing to see if we can put other supports in place to be able to have that youth released from detention. So we really do try to use detention very purposefully. There is a place for detention and youth that need to go to detention, but there also are youth that can be served outside of a detention situation. Like Lindy said, you'll see here the spell out of what the REI, the formal name of the REI, so you see that's the Nebraska Juvenile Intake Screening Risk Assessment, but we refer to it as the REI, much easier to say, right? So we kind of shorten it a little bit. But that's the tool that our probation staff are trained to use when we screen an intake situation. I do want to say here, though, one of the important pieces is they are doing a pretty comprehensive discussion with the youth during this screening. And so most of these occur face-to-face. That is what we encourage probation staff. All areas of the state, law enforcement know how to contact probation in these immediate situations to be able to have support of an intake. And then when probation staff are doing these intensive interviews, if the youth is Health and Human Services state ward or even a non-court case with Health and Human Services, that probation officer is asking questions and may reach out to a caseworker for additional information about what's the history, how have things been going, why do they think a situation like this has come up. So we really do try to get as much information as we can, of course also working with legal guardians if that's the family or whoever that might be, if that is then HHS. So just so you know, that is part of the intake or screening process. That is very important. We reach out to everybody we can to find out what has been going on with this youth prior to choosing detention for a youth. Then you'll see here what the options are that a probation officer is looking at. And so you'll see least restrictive to very restrictive here in the list. But we can release without any restrictions. A youth could come before us and having a neutral party kind of calm down the situation, or maybe law enforcement wasn't able to locate a parent prior to coming to probation. If we're able to do some of those things and really calm down what's going on, determine that the youth could be safe at home, safe in regards to delinquency safe. So I always like to push that out when I say safety. But so that they're delinquency safe at home and they're going to follow the rules, we will release without restriction, and we do that a majority of the time. There are a lot of cases that are released without restriction. The other is we could look at a detention alternative, and so those can range from using electronic monitoring to utilizing some sort of a shelter. And so again, we're also looking at if a parent isn't able to control a youth, but they would be able to be controlled by a different relative. We'll look at that. So we're always looking at what are the alternatives and what are other less restrictive options. Then if a youth is, though, at that highest level, then we would look at either utilizing a staff secure or secure placement. Obviously, a status offense youth could never be placed in secure, but we could use a staff secure setting for a youth like that. But we also will use staff secure for those youth that aren't at the highest risk for detention but need that structure. So then an officer can determine between those two levels of placement, with detention being the highest structured level. I always say to everybody, so I just want to put it on this call too, that if you are requesting or maybe utilizing detention, it's important to go see it. If you haven't seen it, it's important to know where a youth would be going, because it is a very secured facility, and it's good for you to know if a youth is needing to be placed there. And then ultimately, we do have the community-based aid grant funds, so I did want to really put that information out as well. I'm not going to get into the details of that, but these are grant funds that are in all of the local communities have the ability to request these funds. And they can utilize these funds for any kind of alternative to detention that they believe would be beneficial for the youth in their communities. So the benefit of this community-based aid fund legislation that passed is that communities get to decide this is what's the best for the youth in my community, and this is how I'm going to utilize the funds within my community. So it can be extremely beneficial for your local communities, and we encourage as much as we can all of us collaborating and being a part of those discussions to determine other alternatives for youth than just using detention if we have the possibility of using something else. Okay, so that's really the intake piece. Now we're going to talk, we talked some about out-of-home, but again, this is the other really important piece we wanted to hit home on. So we're going to go a little bit deeper into out-of-home placement and utilization between child welfare and juvenile justice. So I'll let Lindy kick this one off.
Okay. So I think I mentioned a couple times, but law enforcement does have the authority in Nebraska to do a removal, and that can be for up to 48 hours. So during that time, if they determine that they are going to remove a child, they're in contact with us. We will meet them wherever. Sometimes it's at the parents' home. Sometimes they're at the police station with the youth. And some of the areas, they might even be at a child advocacy center, like in Omaha, Project Harmony with the youth. And they've made a decision that this child's in imminent danger. They will deliver the child to Department of Health and Human Services, who then has responsibility for finding placement. The other way that a child can be placed out of home, again, is through the court, and the court makes the decision that the child needs to be removed from home. There's basically two types of children that can enter our system. One is a 3A, adjudicated as a 3A, we'll say, and they're an abused and neglected child. Or we do receive some children in our system, and we can receive children that are also adjudicated or determined to be 3C or mentally ill and dangerous. Our primary population that we're serving are 3As, but we do have a few children that fall under the 3C adjudication. Something I'd like to mention too, and I think both Carrie and I would agree to, we take serious utilization of out-of-home. It can be very traumatic for a child to be removed from their home, even in situations that may not be the greatest. And so I think for both of us, we're always looking at ways, how can we keep this child in the home? Can we put interventions in? There are times too where we may meet law enforcement at the house, and rather than just initially law enforcement doing an initial removal, we're trying to think, well, what if we could do this, and we could safely keep this child in the home, and we could get other services in there to help the family. Or maybe one of the parents is the one offending, not both, and so the offending parent agrees to leave the home, and we can develop a safety plan with the family. There's an agreement, so the children don't have to be removed from the home. We also know, and I think, Carrie, I don't know if we've talked about this, but I think we'd agree, also once you remove a child, I know from our research that the longer the child is out of home, the harder it is to get the child back into the home.
We say that all the time, so 100%.
Okay, good. And for some families, if they're having difficulty with the child, it can almost feel a sense of relief. For other families, they may become just feeling less empowered, feeling guilty about what's going on for their child, and so it just gets a little bit more difficult. So it's something, when we talk about utilization of out-of-home, we don't take lightly, and really want to look at ways we keep families more intact and provide those services so we don't even ever have to do a removal, or only when it's absolutely necessary.
Great, thank you. I completely agree with that. I think that if you are from probation and you're on the call, you're like, yes, that's exactly what we hear all the time. So greatly appreciate that. I really liked this slide when Lindy and I put this together originally, because I think it's a picture exactly of this clarity. Because you'll see on the child welfare side, only 3A and 3C. You see on the delinquent side, only delinquent in status. So you can see the very difference between our population. So I love that that's on there. But in regards to juvenile justice, I think I've talked a lot about intake, so I'm not going to jump into that any further. But as you'll see here, that whole temporary placement, that's one of the things we want to push with intake. It is temporary. It's a moment in time. And then with the longer-term out-of-home utilization, that's when we have a court order involved, and that's for our delinquent and status youth. And I loved what Lindy was saying about out-of-home. And just nationally, we hear that out-of-home is very harmful for youth. And like she said, even with a home that may not look perfect, it is better for them to be in a family home as long as they're safe and we can control delinquency when it comes to both of our systems. But I did want to note, you even see legislators supporting this. We now have legislation in Nebraska about exhausted efforts. We have to exhaust all efforts before our youth goes to the YRTC, and now that same requirement of exhausted efforts is out of home as well. So it is essential that we are doing everything we can within a home environment before we remove a youth from the home. And again, like Lindy said, it might seem like a relief sometime to family because they're so involved in this crisis situation, but we can settle that down with different supports in the home instead of removal from the home. So always thinking about what haven't we tried in the home first before detaining or before removing or before recommending out of home. Any of those things come into play. It's so important to the youth we work with and the families. We want them to be self-sufficient and successful. So that's that out-of-home placement utilization piece. All right.
Okay, well, we're getting towards the end of our presentation. But we also wanted to talk about dually adjudicated youth, or sometimes this even goes beyond the adjudicated youth, but children that for one reason are involved in both of our systems. So maybe we could go to the next screen.
Okay.
But we do have some children that have, they have been abused and neglected children, but then other children that are also involved in probation. And it may be appropriate that they're in both of our systems. because they have been a child that's been abused, neglected. At the same time, this youth has gotten into some delinquent or status offender issues. And sometimes they enter the child welfare system first, and sometimes they enter the probation system first. We also have some families in our child welfare system that it may be just one of the children is a probation youth, but there's other children in that home, and they're also at risk for being abused and neglected, or maybe there's even some existing safety threats. And so when that happens, it is critical, it is essential that we work well together. If you can think about it from the family's perspective, they're being told by one system they need to do some things and another system some things, and it is essential that we're consistent in our approach with them and what our expectations are of them. It's also important that we communicate that we both know how this child's being successful or what does this child need. So we just can't say enough about the benefit of us working together and collaborating when we have these children in both of our systems. Also, some things have been mentioned earlier, too, what probation can do and can't do and what DHHS can do and can't do. And so it's important sometimes when the interventions that we're using, is this a probation intervention? Is this for the right youth, the right time? Is this what they need? Or is this a DHHS, which is, and we talked earlier about our focuses, so I'll say for DHHS, is this a focus for safety and well-being of the child? Or probation, is this more of a community safety or for the child that they need something to reduce them or prevent them from further delinquent activity? We always want the youth and the family be the focus, but that's why we're coming together. This isn't just, we have to come together because some administrator said you got to come together, but we're really doing this for betterment of the family. The last bullet, too, talks about the crossover youth practice model, the CYPM, and local collaboration is the key, but there is a model that exists in several of our counties across the state in which they have actually developed plans and how they will work together and communicate. I'll let Carrie, maybe you want to even talk about that a little bit more, but those communities where we have brought up the CYPM, we have seen some great collaboration and work being done and thinking out of the box and partnering together to really help improve the situation or the work that we're doing with the family, and I think even branching out in the community and even our relationships and such with other community partners that become involved with these children as well.
And if you're not in one of those counties, the good news is we really are going to try to move this statewide, and it may not look exactly the same, but it is all about working together, making sure we serve the youth in the best system that can offer them what they need. And one of the really impactful pieces of crossover youth model is if we do have a youth that maybe is a child welfare youth and has received a delinquent charge, there are sometimes where they won't enter the juvenile justice system, and vice versa. We have a youth on probation that it appears they're struggling with a safety situation at home that haven't had to come into the probation system because we've been able to triage them and get them the necessary supports they need without having to then involve them in two systems and being able to be successful in the one that is addressing what they needed because it wasn't truly needing to be involved in each system. Like I said before, we will have youth in each system. So it's not that that is a bad or negative thing. It just makes us work together even harder. And it can be difficult. But the more we get together, talk about things, the last thing we want to do is have families and youth in the middle of agencies that aren't getting along together, or adults making decisions that aren't really in the best interest because of us not collaborating like we should. So one of the reasons that Lindy and I really sat down initially is because we want you to know we support all of you in this. We want you to collaborate. If you have struggles, we have administrative office staff that are collaborating every day and going out and working on situations that are difficult, and they are there for everyone as well as stakeholders. So it's very important to us that we do what we can there. But ultimately, unless you have anything else to add, that brings us to the end of our formal presentation. I don't see any questions in the chat box that came through, but didn't know if anybody wanted to push *6 and ask us any questions or had any questions to place in the chat box. Otherwise, I know that Jim is going to wrap up the presentation.
Okay. I want to take just a moment real quick. If somebody does have a question, you can interrupt me or type it in the chat box. First of all, I just want to say thank you to both Lindy and Carrie for taking time to share all their knowledge and expertise. And also take time to thank them for all their years of service and dedication to Nebraska's young people. So thank you very much. And of course, I'd like to thank all of you for attending as well. NJJA will be doing more of these. And if you want to get more information about upcoming webinars or upcoming online resources, please go to njja.org and sign up for the mailing list. Also, it's never too early. We're going to send out a save the date for our 2017 annual NJJA conference at the Eunice Conference Center in Kearney, Nebraska, May 17th, 18th, and 19th. And seeing no questions, I'd like to just wrap this up and say thanks again to everybody. Have a good rest of the day. Talk to you all soon.